and I have the special privilege to introduce to you our first panel speaker, Ms. Jillian Kirn. Jillian is a US licensed environmental and energy attorney. She has recently been named one of the top 5 US environmental lawyers under 40 by Law 360. In addition, Jillian is part of Climate Change Counsel, a group of experienced lawyers with a shared passion for climate sustainability and innovation. Jillian, it's really a great pleasure to have you as a speaker. Please take it away.
Thanks so much for having me. I'm really glad to be able to join this conversation today. So I'm going to start off just by giving some foundational information that I hope will help further the conversation as the webinar goes on. I think sometimes we just leap directly into the acronyms without getting a full sense of what it is we're talking about. And I think we'll probably all benefit from a refresher. So forgive me if you're all very well aware. But to begin with, we're talking about Corporate Sustainability Due Diligence Directive. I'll answer the rhetorical question of what is it? The European Commission adopted a proposal for a directive on corporate sustainability due diligence in February 2022. And the directive is going to require companies that are in scope to carry out environmental and human rights due diligence throughout their supply chains. Keep supply chains in mind, totally the theme of both today and the next webinar session. It aims to foster sustainable and responsible corporate behavior and to anchor human rights and environmental considerations in companies' operations and corporate governance. Of particular importance, the directive will cover value chains inside and outside of Europe. So that'll be another theme of the day, talking about extraterritoriality. And so it will impact corporations globally. It builds on and also interacts with other regulations that focus on supply chain ESG. For everyone at this panel, I think we probably know that ESG stands for environmental, social, and governance, but considerations that have to do with a company's performance on those 3 areas. So when we talk about other ESG related reporting regulations, that could include, for instance, the Sustainable Finance Disclosures Regulation in the EU, which aims to improve transparency in the sustainable investment market, or the Corporate Sustainability Reporting Directive, or CSRD, which I'll be discussing today as well. And companies will need to integrate due diligence into their corporate policies, identify both potential and actual adverse human rights and environmental impacts from their operations, prevent, mitigate, and remediate those adverse impacts, establish and maintain a complaints procedure, monitor the efficacy of the due diligence policies, and communicate publicly on their due diligence. You might be thinking, is that all? Yeah, for now, that's all. But there are also other things that apply. For instance, the Corporate Sustainability Reporting Directive, or CSRD. What is that? One of the biggest things to know about it is that it will update and operationally replace the EU's non-financial reporting directive, or NFRD, and it will operate in tandem with the CSDDD. Companies will need to disclose sustainability information in their management reports. So that means that financial and sustainability information will be published together, and it will be digitized to make it more accessible and searchable by enforcement agencies, but also the public. So that's something to keep in mind, because where there is more information, there are often more disputes in some ways. So then it'll be subject to limited third-party assurance, meaning that an auditor will evaluate the data. The reporting is supposed to happen under the CSRD pursuant to the European Sustainability Reporting Standards, or ESRS, which is still in draft format. But EFRAG, or the European Financial Reporting Advisory Group, has proposed some standards which lean heavily on double materiality, which I'll talk about as well. There's also a focus on scope 3 emissions, which I think Adolf will speak to in a bit more detail, but one of the key things to keep in mind is that if you have scope 1, 2, and 3 emissions, and it was an iceberg, scope 1 and 2 are up here, and scope 3 is all this down here, and that includes indirect emissions, including from the supply chain. So the CSDD applies to companies with more than 500 employees and a net worldwide turnover of more than 150 million euros, as well as EU companies with more than 250 employees and a net worldwide turnover of more than 40 million euros. But that's if more than half of their net turnover was generated in a high-risk sector. So the high-risk sectors are textile, leather, manufacturing, agricultural, forestry, and fishing, fisheries, and mining. But it also applies to non-EU companies that have net turnover of more than 150 million euros in the EU, or more than 40 million in the EU, and they are also in the high-risk sectors. To keep in mind is that small and medium-sized companies don't directly fall into the scope of the CSDD, but they are nevertheless impacted because they will have to meet standards in their role as suppliers to larger in-scope businesses. So even if they're not falling underneath the umbrella, that doesn't mean that they can kind of ignore the conversation altogether. By contrast, the CSRD has a bit different requirements, but one of the super important things about it is that it's massive in that it quadruples the number of companies that will be required to report. So we had about 11,000 that were covered by the NFRD, and it will be raised to nearly 50,000 that will be covered by the CSRD. And so it applies to EU companies that have two of three things: more than 250 employees, turnover that exceeds 40 million euros, or a balance sheet that exceeds 20 million euros. And for non-EU companies, they need to have a turnover of over 150 million euros. And it doesn't put new reporting requirements on small companies, except for those with securities listed on regulated markets. And then, of course, as a larger conversation, since it's kind of hard to stay away from this, if you're within a supply chain of a larger company. So, a few of the key things that I just sort of like to lay out there for the conversation of the rest of the day are keeping in mind the expansiveness and extraterritoriality considerations. So I mentioned double materiality, which looks at both the impact of the outside world on a company, which is more financial materiality and traditional materiality, and a company's impact on the outside world, which is more impact materiality. So historically, we had said, you need to evaluate how climate change might impact the financial outlook of the company, but this now requires you to look outward as well. And it's a central part of the ESRS and therefore an integral part of, in particular, CSRD reporting. So in the process of doing a materiality assessment, a company determines what topics should be included in their ESG reporting. Supply chain is also name of the game. The CSDD doesn't use the same double materiality language as the CSRD, but it does bring an additional layer of accountability, requiring management of social and environmental impacts along the entire value chain. And it includes both direct and indirect suppliers, as well as their operations, their own operations and products and services. And I know that Marcus will be talking about the CSDD sanctions regime a bit later today, but I will note that regarding extraterritoriality, the CSDD envisages enforcement by member state administrative authorities with penalties for non-compliance and specific duties for company directors to take into account sustainability matters. And so a breach of that of those obligations would be considered a breach of fiduciary duty under the member states' laws. And a civil liability regime will likely also be introduced to allow complainants to sue in-scope companies for damages that could have been avoided through appropriate due diligence measures. If you'd like an example of kind of what that looks like, you can look at the German Supply Chain Due Diligence Act, which has also kind of taken that tack a bit ahead of the trend, for better or worse. So there's a bit of a different approach in the CSRD and SFDR, which don't have the same civil liability regime, and they put a lot of onus on the operationalizing role of the member states. And so that would mean that if you're in Sweden, for instance, like I am, Finansinspektionen would hold a lot of the responsibility for figuring out how to create any sort of relevant sanctions regime and enforcing that. But I also think it's key to keep in mind that we're talking about EU companies, non-EU companies, and they are subject not only to different EU rules, but also ESG regulations that are proliferating around the world, as a net sort of reference. But the alignment of these ESG reporting requirements isn't always great. And I think that that opens the door to additional things kind of falling through the cracks or creating a ripe time for disputes. So to give you an example, we talked about civil liability, where the CSRD doesn't have the same civil liability terms as the CSDD, or in fact, the US's climate-related disclosures proposed rule, which I'm sure will be litigated, but we're using that as sort of a framework to start with. And you have similar issues where you'll have directors' duties only applying in the CSDD to EU companies, but not non-EU companies, and not in the CSRD, but yes, in the SEC rule. And I think that will be really, those sorts of gaps will be really tricky for companies that do business in multiple regions of the world to get their reporting aligned in such a way that it reaches the standard of what all of the regulatory frameworks are requiring. And so as Annette, my colleague, mentioned, we are seeing an increase in litigation. So the cumulative number of climate change related cases has more than doubled since 2015, as she said, and that puts us at over 2,000 cases, but a quarter of those were filed between 2020 and 2022. So we're really cooking with gas, getting some inertia going in this space now, which makes it interesting to follow. And I do think it's important to keep in mind that climate change disputes could be related specifically to emissions, but can also be defined related to greenwashing type claims, or climate change statements or commitments that are not met are considered materially misleading if you're in lawsuits in the US under securities law, and look like false statements about ESG practices. There have also been a fair number of supply chain related disputes in connection with forced labor, human rights, as well as greenhouse gas emissions. And while it was already pretty common for international companies to adopt voluntary international reporting and due diligence standards, this is now even more so prominent on the legislative agenda, which means more and more change. And several regions of the world are sort of enacting new legislation in this space, specifically related to due diligence. And additionally, on the point of arbitration and those sorts of disputes, as Annette alluded to, we see a lot of that coming out of commercial contracts. A clear example could be if you look at M&A transactions, which often address ESG issues in reps and warranties. And it's also common for companies to seek to mitigate and manage ESG risk in contracts with suppliers across their entire production line, which I think will be even more true as companies need to report on what suppliers are doing to try to put best practices of terms into contracts. But then if those terms aren't met, then those clauses might be open to arbitration. And also we can see that there's more and more, if you look at the ICC's 2019 report, resolving climate change related disputes through arbitration and ADR, that was already sort of noting the increased trend in ESG disputes, which has only continued. And it pointed out that arbitration can be a great place or an ideal place for ESG disputes because it allows for the selection of specific ESG expert adjudicators with relevant expertise for the E or the S or the G or ESG as a whole, depending on the case. And that ESG cases are often cross-border, have an international component, which puts them in a really good place to take advantage of the New York Convention and allows you to have judgments enforced in various jurisdictions. And also can be good because if you have the option of emergency arbitrators, it can help facilitate injunctive relief. So I would like to just kind of wrap up some of the things that I've pointed out by saying, what are we going to expect? And I think that even though the directives that I've mentioned today, particularly the CSDD and the CSRD, come from the EU, we can expect a ripple effect around the world, since any company that's operating in the EU and meets the scope requirements will need to comply with the CSDD, even if they're not headquartered here. And in scope, non-EU companies will need to designate an authorized representative within the EU, which is also sort of a crucial contact and difference. And even if you fall outside of the scope of the CSDD, there's a growing pressure to align operations and supply chains with ESG objectives that we can see driving similar legislation in other jurisdictions, including in the US, which I'm partial to because I'm from the US, but also because it's a large economic market. And so I think it matters to a lot of businesses. And even though courts have been the forum for what I would say is the majority of the ESG disputes to date, with the rise in ESG related contract clauses and the inclusion of ESG provisions in international investment treaties, for instance, commercial as well as investor state arbitration, I'd say, is expected to play a larger role in ESG dispute resolution in the future. So with that, I'll turn it over to you, Adolf.
Thank you so much, Jillian, for your very, very informative introduction to the CSRD and the CSDD. Yeah, now it's my turn. I will discuss the impact of the CSRD and the CSDD on particular non-EU entities in terms of adverse climate impacts. So GHG emissions, quite an important issue, of course. Let's start with the CSRD, and I really want to just briefly mention here the obligation to disclose a climate-related plan. So the business model of the company, everything needs to be done in the management reports. Yeah. So the business model, the strategy, it must be in line with the 1.5 degrees Celsius target of the Paris Agreement. Yeah. And greenhouse gas emission reductions, they also need targets in relating to this GHG emission reductions for at least 2030 and 2050. They also need to be included in this plan. We don't have all the details yet because the European Commission is still working on sustainability reporting standards. There will be a delegated act coming up by 30th of June of this year. So it's gonna be we're living in exciting times. I would say because this CSRD, as we heard from Jillian, it's the successor actually of the NFRD, the Non-Financial Reporting Directive, and the NFRD had quite some deficiency because there was no mandatory verification by third parties or auditing firms. And this was basically corrected. The CSRD, also the climate-related plan, this needs to be verified by third parties, by particular auditing firms, and we have a so-called limited assurance engagement. What does that mean? The normal circumstances, when we talk about the financial figures, financial reports, we have a reasonable assurance. A reasonable assurance goes much more into detail. Yeah, of course, the auditing of financial statements. Here we're dealing with, or will deal with, a limited assurance, which is much more on the surface. So, but what's the reason? I mean, the Commission realizes that, but there are just no standards for limited assurance, for reasonable assurance, and that's why they're still working on that. This will take some time, and once those standards are adopted, then we will move over the years for sure to a reasonable assurance. So next. And we've heard also from Jillian already scope 1, scope 2, and scope 3 emissions. The scope 3 emissions are the ones that are hurting the most. They are very, very, I mean, it's basically upstream, downstream. So everything is basically included. It's very difficult to, of course, get this data, and this is also cost intensive. There's no question about it. If you want to find out more about those scope 1, scope 2, and scope 3 emissions, please check out the greenhouse gas protocol. It's very detailed information that you can get there. I unfortunately do not have the time to discuss this in detail today, but the scope 3 emissions, really, it's upstream, downstream, so also customers, everything is included along the whole supply chain. Yeah, so this is very, very intensive. So yeah, this is the CSRD's plan, yeah, as far as keeping in line with the 1.5 degree Celsius targets of the Paris Agreement. Now let's move to the CSDD. Yeah, as we also heard from Jillian, the scope is quite extensive. Actually, around 50,000 companies will be covered by the CSDD. I think most importantly, I'm not even going to talk now about the direct impact, but the indirect impact we have to consider, ladies and gentlemen, in particular also because we have to consider also the foreign entities, the non-EU entities, Chinese entities, US entities, and so on. So the indirect impact, you know, if there is an EU-related supply chain with an EU supply chain leading company directly bound by this CSDD, then of course there will be a mandatory ESG sustainability-related due diligence mechanism. And of course, all the companies, because it will also relate to indirect business partners, will be covered by this due diligence policy. And if a small and medium-sized entity along the supply chain, wherever it is located, wherever it is based, cannot meet those criteria, then it will face probably elimination from the supply chain. Of course, there will be a step-by-step mechanism. First, of course, there will be the supply chain leading company and other direct partners from the supply chain leading company. They will first help to solve this issue. If that cannot be done, then there will be a suspension mechanism. And if the suspension is not helpful, then of course, then the contract will be terminated. This will all be regulated, of course, in the contracts, in the supply chain related contracts. So indirect impact, very, very important. So this will be basically relevant for all the companies. It doesn't matter where they are based, if they are part of a EU related supply chain. When I'm talking about due diligence policy, I'm talking about Article 5 of the CSDD proposal. Make it short, companies will have to have in place a code of conduct containing those ESG related issues that are relevant. Contractual cascading, that means basically it needs to be passed on. All those obligations from the leading company in the supply chain, they need to be passed on until the end of the supply chain. So for example, if an employer is on top of the supply chain, then there will be the main contract with the main contractor, where the main contractor will be obligated to adhere those ESG related criteria, and the main contractor will have to oblige the subcontractor. Subcontractors will have to oblige the subcontractors, and so on until we reach the end of the supply chain. So, but now the main question, ladies and gentlemen, is when we talk about ESG, what is now subject of this due diligence policy? I mean, ESG is a major topic, environmental, human rights, and here we have to take a much closer look at the annex. The annex of the CSDD gives us here a very, very detailed answer. And there's a couple of pages. No need to read that now through, and I'm not going to go through into any detail here, but you just see here, this is a lot of work for the legal counsel, for the departments in the companies. This is really a lot. You better prepare earlier. I know there's a lot of, transition periods, but you should really, everyone should prepare as early as possible because there's a lot to it here too. So this part one here deals with human rights related issues. Then let's move to the second part here. And the second part is environmental impact, adverse environmental impact. And here, ladies and gentlemen, you may look for the Paris Agreement. And that's the major weakness. That's the major weakness. Yeah, it has been pointed out already by NGOs. You don't find nothing, absolutely zero, about climate, about adverse climate impacts in this annex. So what does that actually mean now? You see that on the PowerPoint slide here. Adverse climate impacts do not have to be included into a company's due diligence policy and the code of conduct. Yeah, that's really amazing. It's a major weakness. The EU Parliament is aware of it. So, ladies and gentlemen, this is not the Commission's proposal. We already have a standpoint from the Council, and now it's heavily discussed in the EU Parliament. In particular, we have now also already comments, viewpoint from the EU Parliament's Environmental Committee, it was pointed out that this is a major issue. So the Parliament pushes for including in this CSDD's annex also adverse climate impacts, in particular the targets of the Paris Agreement. Yeah, we will have to see the outcome. It will be heavily negotiated in the course of the year. I think the CSDD will be adopted. Yeah, and for the environment, we only can hope that this adverse climate impacts, because the interesting thing is when we talk about adverse environmental impacts, ladies and gentlemen, don't be confused. The adverse climate impacts are not included in this term. Yeah? So we have to be very careful about it. But does that mean in terms of in terms of the CSDD and the adverse climate impacts that the CSDD is absolutely not useful? No. Because we have Article 15. Again, we're talking here about this plan, and you heard it already in connection with the CSRD. So basically, here is the obligation to have such a plan, to draft such a plan, and the CSRD, then there's the obligation to disclose it in the management report. Yeah, and I think we heard it already quite well also from Jillian. The more a company publishes, this can lead to major issues. It will give rise to potential greenwashing claims, climate-related litigations, and so on. So I think it's already quite a good step to have such a plan in place. So even if we don't include the adverse climate impacts in the annex, in the final annex of the CSDD, this is already a very, very good way to ensure the fulfillment of the criteria of the Paris Agreement. However, we have here, Article 17, supervisory, this also needs to be controlled, of course. So each member state will have supervisory authorities that needs to control that. Council's position is rather shaky here. it says here, member states shall only require supervisory authorities to supervise that companies have adopted the plan. And that means that supervisory authorities will not have the power to assess the implementation of the plan. But again, we have to see the final product, because Parliament is very much in favor of being much more strict. Yeah, again, climate washing, greenwashing, the more, and I repeat it again, the more a company publishes, the more it needs to be careful, because it will definitely trigger climate-related litigations. And that brings me to the practical cases. I think later on we're going to hear much more about the Shell case. That's why I'm not going to go into any detail as far as the Shell case is concerned, but it's really amazing. It was a groundbreaking judgment by the Hague District Court, where Shell, and you have to think about that, 45%, it was the judgment that Shell is now actually obliged to reduce its GHG emissions compared to the 2019 levels by 2030, yeah, worldwide, scope 1, scope 2, scope 3 emissions, yeah, worldwide, covering all the supply chains. Yeah, so Shell needs to reduce its GHG emissions by 45%. So that's a statement. Yeah, we have to see in the future if other jurisdictions, I mean, this is of course the Dutch jurisdiction. If other jurisdictions follow, we will have to see. It brings me to my next case, jurisdiction of France, Total Energies. There's a greenwashing case going on, heavily disputed. Greenpeace and other NGOs, they're currently suing Total Energies, the French oil and gas giant. Yeah, there's the allegation in the room that Total Energies' carbon neutrality commitments would mislead the public. So you see, that's marketing, that's the reporting, yeah, and that's how you can get to a greenwashing claim. So would mislead the public, taking into account Total Energies' continued investments in fossil fuel projects, yeah, and Greenpeace also, I mean, takes that very seriously, and they published a report alleging that Total Energies' GHG emissions are actually 4 times higher than reported by Total Energies. So we have to see the outcome, but there's another litigation now on the way, actually initiated this time by Total Energies, as a reaction to the Greenpeace report. Yeah, we have to see, but it's more and more going on. That, as Jillian said, also we have already thousands of these cases. It's really moving. So about the Borealis case, there's now also an ESG related, or was last year, an ESG related project called I'm going to talk next week, when I'm going to talk about the supply chain arbitrations. Finally, I'd like to really draw your attention to NIO. NIO is a Chinese electric car manufacturer, and now NIO is expanding in the EU. They are already now in four EU countries, Germany and Denmark included, and they're also listed on the New York Stock Exchange, and that means they have very intensive reporting requirements on the Form 20F. And I uncovered here something very interesting on the page 42 of this 20F form. We do not, and that's NIO, it's not me, I just quote here. This comes directly from the report. We do not control our independent suppliers or their business practices. And they realize here, accordingly, we cannot guarantee their compliance with ethical business practices such as environmental responsibilities. And they realize also here in the second paragraph that this could harm, basically, this could bring negative publicity and so on. I mean, you can read yourself. It could harm the brand image. It could lead to the loss of customers and all the negative consequences. Still, they don't control their suppliers. Okay, and the last thing I want to add is Shell. You know, the company that just had this judgment from the Hague Court. Shell has a cooperation agreement, a very intensive cooperation agreement with NIO. Yeah, so that's going to be quite interesting because Shell now is obliged. I mean, the cooperation agreement is about charging stations all over the world and so on. Yeah, battery charging stations for the cars, for the electric cars. So now it's going to be very interesting. Shell has now this judgment. It needs to already basically implement this judgment. Yeah. And now they have the direct business partner NEO that does not control its suppliers. So it's going to be very interesting to see how Shell handles that, probably with contractual clauses forcing NEO to actually check its controllers in terms of GHG emissions. We will have to see. This is going to be a very interesting topic, but it's really, really interesting to see.